On Sunday, the 15th of March, the judiciary temporarily suspended court hearings across the country. As of today, most hearings are still on hold except for very urgent matters and the delivery of judgments. Today, Chief Justice David Maraga ruled out open court sessions for now, citing the risk of the transmission of the deadly COVID-19 disease. The decision followed a recommendation by the National Council on the Administration of Justice, which CJ Maraga chairs. Joining us to talk a little bit about that, live from different locations, Charles Kanjama, an advocate of the High Court. He was also a presidential candidate in the just concluded, or a couple of months ago, LSK election. Charles, thank you for speaking with us. In addition, we have Maria Mbeneka, an advocate of the High Court and a council member of the Commonwealth Lawyers Association representing East Africa and the Seychelles. To the both of you, thank you for joining us on Newsnight. Let me first get your reaction to that statement read by Chief Justice Maraga. Maria, let me start with you on that one. Your thoughts on that move to rule out open court sessions for now?
Thanks, Wahiga, for having me. Hi, Charles. I think that statement is not surprising, considering some of the reactions that we have witnessed from the judicial officers who have given their views about the preparation of the courts in terms of being able to provide protective gear for their staff. So we have seen pushback following a meeting that the NCAJ had last week with the stakeholders, and the judicial officers were very concerned about the preparation or the preparedness by the judiciary to be able to handle. Okay. So I'm not surprised by the CJ's reaction.
Let me also bring in Charles. Charles, you tweeted quite a bit after the Chief Justice read that statement. One of your tweets said, with that statement today, reversing gradual scaling up of the court operations, access to justice and open justice have suffered a significant blow. Just talk to us about that, Charles.
Wahiga, I have been fortunate enough to be part of the team of LSK that has been engaging the judiciary in the subcommittee of the National Council of Administration of Justice. I'm current chair of the Nairobi LSK, which has about 75% of lawyers. And we've also been having consultations with other branch chairs of the Law Society all over the country. And lawyers generally have been quite concerned with how rapidly the judiciary scaled down. And the concern of lawyers has been that the judiciary has gone much faster and further than other arms and organs of government. And we've been urging them to reverse a bit the close down or the lockdown of the courts. We've been telling them that it is possible to implement social distancing measures and have some services proceed. So the decision that had been reached last week was one that was really welcomed. Various LSK officials engaged judicial officers in the different parts of the country. And they had already come up with very useful consensual positions that were suitable for each part of the country on how justice could continue. Okay. So what has happened with this statement is that it has reversed all that. And we as stakeholders in LSK, we are a bit taken aback and disappointed.
Let me ask you this. So first of all, give us an idea of what you expected, what you had hoped to hear today. And when you talk about social distancing in a courtroom, many struggle to imagine what that will actually look like, because we've seen what our courtrooms have looked like, for very many years.
You are very right, Wahiga. We have been saying that supermarkets are normally totally crowded. Matatus and buses are normally totally crowded. But during the COVID-19 situation, they have all come up with mechanisms for social distancing. So all institutions that tend to be crowded have come up with measures. Even Parliament has come up with some measures to effect social distancing. So the courts were going to do that. For example, we were saying, if you can have 2 hearings in a day with only the lawyers or the parties who are appearing, no one else present in court, and they don't come in at the same time, you can have one case starting at 9, another case starting at 11. You could implement social distancing measures. You could have some documents filed physically. Those are things that could have been done. What we are now seeing, Wahiga, if I may just put it clearly for your viewers, is that the second term of the judiciary which normally starts after Easter and goes until end of July, is basically collapsing. It's being abandoned. That's an extra 3 months of backlog in addition to the 1 month that we saw. And we do not believe that the judiciary can simply completely lock down physical access to the courts.
Okay. The
same way other government agencies are still operating, even with senior government officials, but with social distancing.
I guess, Charles, the challenge with the courts is that you can't just operate without the litigants coming, to seek your guidance on the same. So some would argue against that. But Maria, I can give you a chance to respond to what Charles has said. Even as you think through this, there are those who say one of the reasons why lawyers are really pushing for the courts to reopen is for commercial purposes.
Look, it is not lost on us as practitioners that many of us earn our fees through litigation and attending court. So if your matter is not proceeding and you are not able to conclude a matter, for example, if you just had a hearing and then you present your fee note, you'll not get paid. So the fact of the matter is that there is loss of business where, as far as lawyers are concerned. What I want us to focus on is the long-running program that the courts have had in terms of digitization. And what COVID has done is thrust all of us into a space where we have to get on with technology. Now, when the CJ talks about scaling down of court operations, we have to be alive to the fact that some matters are proceeding, especially the urgent ones. Pleas are being taken. But what the majority of the work that is being done is that judgments are being delivered. You and I know that there's been a backlog even before COVID. 2019 economic survey talks about 571,000 pending cases in 2018. Now, what this pretends is that, of course, there's a build-up of the backlog. So the CJ talking about rolling out technology and upscaling the use of technology, because that's what the statement of the NCAJ says. And I presume NCAJ here includes LSK, the DP, the prisons, the IG. So you have a situation where there's talk of upscaling of technology, but what is seen on the ground is that it's not actually available across the board. So there's an urgent need to provide the necessary finances and infrastructure for practitioners to have access to the courts. Even if the courts are opened physically, the judicial officers will want to maintain social distance. How will they do it? So, because it's about 40 matters in a day. Yes,
sorry to interrupt you. So one would then ask, so digitization of the judiciary sounds like a pretty good idea, Maria, and it's one that the current Chief Justice, the previous one, had been promising. But for that litigant who's fighting over a land matter, who is not tech savvy, will this digitization favor them? How will that work for them?
Now, look, the judiciary has to prepare accordingly in terms of availing these services, either at the judiciary itself, and I propose even taking advantage of Huduma centers and LSK branches so that members of the public can have access to some of these basic facilities. Because remember, Wahiga, the CJ has already gazetted the practice directions as far as e-filing is concerned. So when we talk about people being able to file their documents, this has to be disseminated to the members of the public in a meaningful way. Is it available on USSD? Do they have assistance or a kiosk where they can get assistance at the judiciary?
Okay.
And this has to be done across the board. You have to talk about courts in the villages. What happens now to the mobile courts, for example?
Lots of questions indeed. Charles, I have a question for you from a viewer who I guess has chosen to remain anonymous, but they are a lawyer and a member of parliament. Please ask Charles Kanjama this. In light of revelations that droplets from the virus can survive on surfaces, paper, cardboard, tables for up to 3 to 5 days, registry clerks and judges would have to deal with bulky papers with no way to ensure their sanitation. How do you sanitize court papers that have been filed, Charles?
Okay, so Wahiga, there are so many suggestions that we had made as LSK, and there were more that we were making. But before I answer the question of the Member of Parliament, allow me to say this. A vaccine will be developed in 12 to 18 months. The experts are saying that coronavirus will be with us for that period. So the first question is, if we cannot get 100%, you could say, prophylaxis from the possibility of being infected, do we close the courts for 18 months? It's a very simple question. So the answer is that we must look for a balance where we put in place social distancing measures, but we allow rule of law, we allow the economy to proceed. So for example, in regard to paper, you have things like gloves, you have face masks, you have frequent wiping of surfaces, you have documents being filed concurrently in digital and physical form. You have various things that are being done, even in other government agencies and departments. It cannot be that we are unable to find a solution within the next 18 months because there are some coronaviruses that will be floating around during this whole period. That is what the experts have said, until we get a vaccine.
Okay, until we get a vaccine. So when you look at, and we've got lots of statistics about how much backlog there was before COVID-19. In your view, Mr. Kanjama, how bad or how serious do you think the situation is in terms of a backlog, bearing in mind, open courts have been suspended since the 15th of March? What do you think the situation is right now?
So, Wahiga, I have spent 4 years as the chair of the Nairobi branch. I'm about to retire and hand over to the next team in a month's time. And what I can say is that we have worked very well and collaboratively with the judiciary to deal with a backlog that was extremely substantial. There have been challenges because of the attrition of judges and magistrates. And when the JSC has tried to recruit new judicial officers, the president has delayed in appointing them. So what has happened is that over the last 1 year, the backlog, which we had started tackling through a collaborative effort, has begun growing. Is that a delay of 4 months, because it would mean 4.5 months that the judiciary not have sat from March 16th until the end of July, will create a major backlog challenge to the judicial officers. And the cause list, every day a judicial officer tends to have 10, 15, sometimes 20 matters that they must deal with. These matters have now collapsed virtually, apart from very urgent matters and rulings and judgments. So this cause list, you can imagine, you multiply 10 or 20 cases per day times 3 or 4 months. And that is the kind of backlog we are talking about. And new cases, of course, and new issues continue emerging. So it's a major challenge. If we go to the criminal justice system, the courts are basically dealing with pleas, but hearings again have been suspended. So you can imagine people who've been spending years in the criminal courts will now need to add an extra 1 year because of this challenge. And if we don't get a resolution, yes, things will get worse after the summer vacation of the courts. That, I'm sure, is not good news for many of our viewers here tonight. Maria, let me come back to you and try and move you forward. It's the 1st of June or the 1st of July. The National Council and the Administration of Justice have sat. They found a way to get the courts to reopen. What will the justice system look like when the reopening happens, in your view? Because for many, it sounds like to be quite chaotic.
If the CJ seizes this opportunity to actually digitize all the courts, this is the legacy that is actually being handed to him by circumstances. So if the judiciary gets its act together, we have reached a point of no return, in my view. The future is that we will be filing our documents electronically. What will happen is that we need to move now so that we are not playing catch-up and having a chaotic situation. But if nothing is done and we are still stuck with the old way of filing documents physically because we've not rolled out the digitization across the country, then we are going to have a problem. Remember, it's not just litigation that lawyers carry out. We have the land registry, which is closed. That has presented its own headache, and it's a real nightmare for practitioners in that area. Yet you have registries such as KIPI that deals with intellectual property, continuing with their work. the copyright board is saying they are still receiving applications online. So the government really has an opportunity now that it should seize and ensure that government services are actually fully migrated, but not lock out the legal profession in the process.
So do you agree, or what are your thoughts of, I would say, doomsday prophets who feel that when the courts reopen, the rush that will be there, litigants who had cases that were already ongoing, trying to find out where are we on the cause list, people with new cases also trying to get in with their lawyers as well. Is that the kind of situation you would foresee? Because some say that's what will happen.
Well, I foresee a situation where we probably have very rapid service weeks, with the matters then being fast-tracked. But remember, as a judiciary, the judiciary has adopted ADR, which I know for a fact has stalled. And this is sad because, the fact that we've not mainstreamed these processes digitally. So things like arbitration, mediation, those have taken a backseat, whereas they would have actually tried to de-escalate the situation at the moment. So I'm going to foresee a situation where we will have service weeks, probably for 2 or 3 months, to deal with matters that were urgent. Well, it's unfortunate, but there's an opportunity here.
You see?
Yes.
You see an opportunity
to actually adopt technology. Of course, funds, being available. There's goodwill from the members because they want their matters proceed, whether it's electronically or physically and observing.
Go ahead, Charles. Go ahead.
Let me also say that I think I support the idea that we have to take advantage of the current opportunity to get the judiciary digitized more. There have been programs of digitization that have been going on. They have faced several challenges, one of which is withdrawal of budget by Treasury. Like in the 2018-2019 financial year, the entire digital budget of the judiciary was withdrawn, and that delayed some of the deployment. So right now, the platforms that would enable the judiciary to work really effectively through digital means are not in place, except a pilot program that is at the High Court Commercial Division in Nairobi and the Chief Magistrate's Commercial Division. So even as the judiciary has been trying to very manfully use the available technology that is not at a very high platform level, like emails and so on, there has been a lot of inefficiency. And that is one of the reasons why lawyers have been saying, can we gradually start upscaling services? The other thing, Wahiga, is that working from home, we have been saying for many people equates to home. And not much work is going on in the homes. And we've been trying to encourage the judiciary leadership to have robust performance management systems that they can use to engage the judicial officers and the judges and the other staff in the judiciary to ensure that those who are able to do work at home at least are productive. And these are discussions that have been going on. One thing I can say for sure, because I think I've been talking for some time, is that when you have a kind of like wide statement, like what came from the Chief Justice today, that people work from home, it actually reverses some of the gains we have been having in encouraging judicial officers to make progress. A judge to even write a judgment needs to go to the office or get someone to go to the office, collect the physical file, bring it home, do the research. They need to coordinate with their secretary and their judicial researchers. For magistrates, they have to do something similar just to get a judgment done.
Effectively, you're saying it doesn't make sense to work from home if you really want to provide justice to citizens at this time. And some would even ask, how would this digitization happen if the officials are at home and the files are at the courts or at the registries? Or in the office as well. Charles, a tweet here from Isaac Okero, who former LSK president. He says that the volume of human traffic or documentation that courts see far exceeds what ordinarily flows through the office of the executive and the legislature. It follows that the manner in which courts must be made COVID-19 safe must be different. You can't compare how the courts will be sort of tweaked to be made COVID-19 safe as compared to the legislator or the executive. How do you respond briefly to that, Charles? You can't compare with Parliament or with president's office. Yes.
First of all, let me say that we want digitization hand in hand with physical processes. The two should go together. What has happened, for example, in the criminal justice system, the volumes are still there, but they're in the police station. So the rights of Kenyans, which are meant to be protected by the judiciary, are not being protected. How are police stations dealing with volumes of suspects? The judiciary has to use the same method, because now, basically, if the judiciary flees to the hills, what that means is that the police stations become the new courts. And if police officers decide to engage in extortion, there is no recourse because the judiciary is not there.
Okay.
So there are various other government agencies that are dealing with volumes of people because there is some modicum of movement in Nairobi and in other towns. So the judiciary has to find a method. Allow me to finish by saying this way.
Briefly, please.
Assuming there are going to be 1,000 people to visit the court, it doesn't mean that you only have a binary option, either 1,000 or 0. You could decide to say only 30. But now we are choosing it, we are looking at it as a binary option. Either you get 1,000 people in or 0. Why can't we have a mechanism where we limit them to say 30 or 50, whatever number we think is safe?
Okay. Charles and Maria have some feedback. I want to read them quickly, give you a parting shot as we wrap up this discussion. These are some of your thoughts. 22422 is the SMS line. Hashtag is Newsnight. Let's put them up. All right, okay, so some, I thought they were related. Okay, Keep Letting says, quarantine not for everyone. Those suspected to be COVID-19 positive should be taken to quarantine, not just everyone. Okay. Let's see what we have on Twitter. P. Jumbe says, it's unfortunate we've taken COVID-19 for granted. That clip of people escaping from quarantine means our level of discipline is wanting. This is one war we need to jointly fight. Okay. And KOT Loyal say, what exactly are quarantine centers? Are they isolation centers for people who have come into contact with COVID-19 patients or correctional facilities? The government is confusing the two. And a few more. The Ambo GPS says, if what I've been seeing is anything to go by, then we are far from exiting COVID-19 Kenya. Citizens playing limbo with the government over this matter. We're becoming more and more reckless with each day. Quite unfortunate. All right, one more. Louis Tony says Kenyans should cease theatrics, heed to government directives as far as prevention of COVID-19 is concerned. Last one to Maria Mbeneka and Charles Kanjama, who are still live with me. Tonight, what is your advice for someone with a matter in court that was ongoing before the suspension of the courts? And what is your advice to someone who wants to take a matter to court as soon as the courts reopen, sort of for everyone to be able to access? Maria, let me start with you.
One is to take advantage of the fact that the judiciary has said that they're going to upscale through technology. So file your documentation online, prove your case to be urgent, and make an application to be heard. There are matters that are being heard, and it is my biggest concern is where. So hopefully that these people have their matters heard in courts that have access to this technology. Number two, we need to provide a way forward. It's easy for us to say that the chief has moved and lament, and I've seen a lot of these comments in our forums where people are actually complaining. What we need to do is provide options and solutions to the judiciary as stakeholders. The judiciary should set aside hearing rooms or booths because you also have to remember that there are matters where cases are heard in camera. Usually these happen in chambers. So all the judiciary needs to do is provide, especially at Milimani, the High Court, this space, and considering that they've scaled down operations. Number two, you need to have the LSK itself supporting its members to access technology, because if you don't have access to technology, then you'll not be able to work. So there's an opportunity here for LSK to get into an arrangement either with the SACCO or some financiers to be able to get our members cushioned. I know that they've provided some relief for those who have not applied for their practice certificates.
Okay.
So we need to be able to work together as stakeholders of the judiciary and provide solutions. The branches have offices. These can be used for hearing rooms if we don't have to access the courts. at the branch level until the courts have fully caught up with the digitization program.
Okay, Charles, before you have your parting shot, Member of Parliament for Mathare, Anthony Oluoch, says Article 159 of the Constitution encourages alternative dispute resolution and arbitration. Is that not one viable option? LSK should take that up. Go on massive civic education to encourage litigants to use ADR. Then there's the small claims court. People can file claims online and not have to appear in court. And thus the backlog will be for complex commercial claims. Charles, as you give us your parting shot, do you see scenarios where cases could be pushed for 2 to 3 years because of this?
Yes, for sure it does happen. I think any litigator, and I'm one, knows that an adjournment of a hearing sometimes can result in a delay of 1, 2, or 3, just because of various circumstances, including judicial transfers that happen thereafter. Allow me to say as my parting shot, number one, that under Article 159 and 160, the judiciary exercises delegated sovereign authority of the people of Kenya. It is one of the 3 arms of government. The Chief Justice of South Africa, Mogong, has said that the judiciary cannot pack up its tools and go home. In fact, it is very necessary. The same way we cannot expect the Minister of Health or the executive, the Cabinet Secretary of Interior, to pack up and go home, maybe because they are 60 or 65 or 70, because the country must run. It's the same way that the judiciary must run. The people of Kenya expect justice, they expect rule of law, and we as the Law Society of Kenya and are committed to ensuring that, be it a state of pandemic or national emergency of any kind,
yes,
the rule of law prevails. And secondly, the rule of law is a process. It's a value chain. It is not just what happens in the court.
Okay.
It starts at the moment when justice is threatened, whether it is in homes where there's domestic violence, whether it is in the streets, whether it is in police stations. Lawyers must be there, and including in the courts. And that is why we are delighted that the High Court recently declared lawyers as essential workers. This is not for our own privilege. It is so that we can represent members of the public. I would like to finish by urging
briefly, please,
lawyers,
okay,
innovative in alternative dispute resolution,
yes,
judicial officers to be courageous and prudent at the same time, and be ready to rise up to the occasion of administering justice in the COVID situation.
Okay. I believe that was his parting shot. We seem to have lost him on that last line. We've had Maria Mbeneka, advocate of the High Court, a council member of the Commonwealth Lawyers Association, and of course Charles Kanjama, advocate of the High Court, outgoing chairperson of the LSK Nairobi, and also a former LSK presidential candidate, joining us to talk about access to justice, a topic I'm sure we'll be discussing quite a bit here, even as the effects of the COVID-19 pandemic continue to be felt. With open courts continue remaining suspended, what happens to litigants with active cases? What happens with those who wanted to move to court over an issue over the last 1 month or so until the courts can be fully reopened? And so those are some of the thoughts of senior advocates tonight. Thank you for watching this program. This has been Newsnight. Thank you for being a part of the broadcast. My name is Wahiga Mwaura, and our sign language interpreter has been Yulanzale. On behalf of the whole team that makes this program possible, good night, and thank you for being one of our viewers. Good night.